in the sense that I must apologize because there was an error in the assignments given. When I was first invited to do the bar review, I was told that I would do labor standards and labor relations law. In other words, including welfare legislation, the entire coverage of the bar examination. And so accordingly, I prepared a schedule for both. All three laws, and I prepared an outline. In fact, I brought my teaching outline to make sure that I cover all. But when I reached the office this morning and I took a good look, I actually picked, because it's not my copy, it was on the table. And lo and behold, I found out that I'm not supposed to discuss labor standards and welfare. Rather, I should take care of labor relations law. And so I have a problem. I did not bring my teaching outline in labor relations law. Neither did I bring my teaching outline on the law on termination of employment. Which means I have to revise the entire schedule all over again to make sure that I cover my area. But I have a second equally important problem. I have been asked to plow the field all over again on labor standards law. And it raises an ethical dilemma for me. For the simple reason that your reviewer is my colleague in the legal profession. And you all know very well that in the Code of Professional Responsibility, one of the chapters is the obligation of a lawyer towards another lawyer. I would, in effect, if I enter the area, that would be forcible entry under the rules of court. And if I stay a minute longer, that is unlawful detainer. And certainly, you will appreciate the problem that I have. It's not that you will not tell. The point is, that's not my assignment. All right. I will go through it very quickly and very fast, if that's what you wish. So for purposes of the bar examination, you are expected to be examined first on the law on labor standards, which is Book 1, Book 2, Book 3 of the Labor Code. Book 4, which is welfare legislation, otherwise known as the Employees' Compensation and State Insurance Fund law, is not included in the bar examination. God is merciful, because if it were included, you would certainly have quite a problem in your hands. Instead, for purposes of welfare legislation, only two laws will be included. The GSIS law for employees in the public sector of the economy and the Social Security law for employees in the private sector, including the limited portability law. The limited portability law covers and attaches the two laws together to take care of situations where a worker would not qualify for benefits under either law, but the limited portability law will allow the tacking of the length of service in the two laws. So you have taken care of labor standards. Second law you would be examined is labor relations law, which is Book 5 of the Labor Code for those employees in the private sector of the economy. For employees in the public sector of the economy, they are covered by Executive Order number 180 which is the law on labor management relations in the government service, which includes employees of government-owned and controlled corporations that are organized under the general law, that are organized under a special charter, otherwise known as government-owned and controlled corporations with original charter, for the very simple reason that under Article 9 of the Constitution, employees of government-owned and controlled corporations organized under a general law or special law are government employees by definition, because the law distinguishes between employees of government-owned and controlled corporations organized with a special charter. They are by definition government employees under Article 9 of the Constitution. And secondly, employees of government-owned and controlled corporations organized under the corporation law, they are covered by the labor code. In addition, you have the law on termination of employment. Make no mistake about it. There is no bar examination that does not have a question on Book 6 of the Labor Code, for the very simple reason that Book 6 arguably is the most litigated area in the Labor Code, aside from employee classification. And in addition to that, there are two special laws. One, the 13th month pay law, Presidential Decree number 851, and the Migrant Workers Law, and thirdly, the Anti-Sexual Harassment Law. So what are these laws all about? For purposes of definition, labor standards law is that branch of the law which provides for a statutory floor below which it cannot be allowed to fall. And what is the statutory floor? The statutory floor are the minimum terms and conditions of employment which society deems necessary for the safety and welfare of the worker and his family. The thrust of the law, therefore, is there is a floor. It cannot be bargained below. It cannot be unilaterally reduced. These are what the law says are the minimum standards of employment necessary for the welfare and well-being of the worker and his family. Thus you have our legislation, minimum wage legislation. Labor relations law, on the other hand, is that branch of the law which regulates institutional relationships. Institutional first because the worker is not speaking as an individual worker, although in certain instances he may well be doing so. The worker in labor relations law is speaking in unison with his fellow worker, and there is what is known as a labor union. And so the thrust of the law is the right of self-organization, appropriate bargaining units, strikes, lockouts. And the companion law is EO 180 for employees in the public sector. They are almost exactly the same, except that employees in the public sector do not have the right to engage in strike activity, although they have the right to peacefully assemble after office hours to seek redress. And secondly, employees in the government sector performing purely governmental functions, or employees of government-owned and controlled corporations with original charter cannot negotiate exactly the same as employees in the private sector, simply because When the law has provided for the terms and conditions of employment, they are non-negotiable. What can be negotiated are matters not covered. And lastly, you have welfare legislation. Welfare legislation is designed to provide for continuity of income in whole or in part whenever certain defined contingencies occur. Its intent is not to make the worker a charge upon society. Rather, the law will try to restore in whole or in part income lost because of certain defined contingencies. And you have two laws, GSIS law and the Social Security law and the Limited Portability law. You have therefore defined all branches of the law and its major areas of concern. But you must all bar reviews must begin with the constitutional foundation of labor law. It is worth your while to study the constitutional foundation of labor law for the very simple reason that as you read the provisions of the labor code, you will note that the labor code is designed to implement what is in the Constitution. In fact, if you do not know the answer in the bar examination, but you know the Labor Protection Clause of the Constitution, and you can write some parts of it, you will at least be entitled to some points rather than a fat 0 for your grade. So what is the constitutional foundation of labor law? It begins with the Bill of Rights. The Bill of Rights in relation to the characterization of the labor sector of society. You will note that the labor sector of society under the Constitution is characterized as a primary social and economic force. But that provision of the Constitution, that labor is a primary and social economic force, includes another sentence. The second sentence says the state is mandated to protect and promote the rights, benefits, and welfare. You will note then that at the heart of the Constitution is the recognition of the role of the labor sector in Philippine society, a primary social and economic force, and secondly, the mandate that the state must protect and promote their welfare. Then you have the Due Process Clause. The Due Process Clause says, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. And you will note that when you are studying labor law in the classroom, two things. First, by definition, labor is property within the meaning of the Due Process Clause. And because it is property within the meaning of the Due Process Clause, when that right is violated, there is a cause of action and a remedy is provided for by law. Second, you will also notice that when you study the law on termination of employment, that is the employer's final defense. The employer's defense is, my business is my property. I too cannot be deprived of my property without due process of law. And if there's one article that you should probably memorize, it's rather long. It's Article 13, Section 3 of the Constitution. Article 13, Section 3 of the Constitution is otherwise known as the Labor Protection Clause of the Constitution. It's long, but you can cut it down to small pieces so that it is manageable. The first sentence of Article 13, Section 3 of the Constitution maps out a territorial boundary. It sets the entire tone. The state shall afford full protection to labor. Full, whether organized or unorganized, whether local or overseas. The word full, if I may bring you back to your classroom, is an amendment to the 1987 Constitution. The word full was inserted to make sure that the mantle of legal protection is extended to all workers, whether unionized or not, whether working in the Philippines or working abroad. Second is the statement of guarantees, otherwise known as the cardinal rights of labor. And you will note that those guarantees either are labor standards guarantees or labor relations guarantees. The labor relations guarantees are the right to self-organization, 2, the right to bargain collectively, and the right to engage in peaceful, concerted activities, including the right to strike in accordance with law. That sentence, the right to engage in peaceful, concerted activities, including the right to strike in accordance with law, is the purpose and means test that you have studied for some time in labor relations law. Then you have labor standards guarantees, security of tenure, just and humane conditions of work, a just and a living wage. The next part of Article 13, Section 3 of the Constitution refers to the preferred mode of dispute settlement. And it says, the state favors voluntary modes of dispute settlement, including collective bargaining, conciliation, mediation, and arbitration. At this point in time, I don't know if you have been hearing the rumor. The chairman of this year's examination committee is Justice Conchita Carpio Morales. And she is alleged to have said that the examination will be a little different because the questions will be analytical. Analytical means you don't just memorize, you understand the reason behind the answer you are giving. And so I'll try to introduce to you the concept of analytical. It says, preferred mode of dispute settlement is voluntary. The reason behind that provision of the law is that real and lasting industrial peace cannot be achieved by compulsion of the law, but it must rest on an essentially voluntary basis. That sentence is not mine. I do not claim ownership over it. But that sentence, real and lasting industrial peace, cannot be achieved by compulsion of the law, appeared in the original Republic Act 875, which is now Book 5 of your Labor Code. And there is the provision of shared responsibility and mutual compliance with the obligation. And finally, there is the provision that labor and capital are entitled to a just share in the fruits of production for purposes insofar as the employer is concerned for expansion and growth. if there's any provision in the Constitution that you will always encounter in any decision you have read in the classroom, you will notice it always returns to Article 13, Section 3 of the Constitution, because the Bill of Rights on the characterization of the labor sector, the Due Process Clause, and Article 13, Section 3 of the Constitution is the foundation of the entire labor code. It is the constitutional foundation. But three other articles are relevant. One, with respect to the employment of aliens, you will recall that in the labor code allows the employment of non-resident aliens, provided they include and have a working permit. I am sure Professor Alcantara has explained it. But if you go back further, you will find that in the Constitution, what the Constitution provides is preferential use of Philippine labor. It does not prohibit the employment of aliens. But aliens here are defined as non-resident aliens. The reason why the law allows the employment of non-resident aliens is there is a transfer of technology for the purposes of national growth and development. Second, there is the provision in the Constitution on the role of minors in society and the concern of the state for minors. The theory of the law, or the rationale behind the law, is that the minors are the future citizens of the country, and therefore the law must nurture their growth and development. And finally, women. Women are entitled to special protection of the law, and the ancient theory that they are the weaker of the sexes. And I am not sexist by any definition. And secondly, that there are predatory males all over the world. This is no longer the reason for today. Today's reason for the special concern of the law for women is that the mothers of the race. If they do not exist, there is no race to speak of. So you have taken care of the constitutional foundation of labor. But you must know very well, how do you balance the conflicting claims of labor on the one hand and the claim of the employer on the other? Why? Because labor claims that the state shall afford full protection to labor. On the other hand, the employer will also claim that I am entitled to the protection of the law. How do you balance these conflicting claims? If you read your textbooks, you will know that there is a litany of cases. I said litany because there are so many, but you can distill it and reduce them to 3 or 4 sentences only. First, while it is true that labor is entitled to special protection, the employer is also equally entitled to protection, for the reason that the Constitution of the Philippines was not designed to oppress nor destroy the worker, the employer. In other words, when labor is right, yes. When the employer is right, the employer must also be protected, for the very simple reason that the provision of the Constitution was not designed to destroy nor oppress the employer. Second, fundamental judicial doctrine states justice according to law, justice according to facts, because justice is supposed to take care of all. And lastly, you cannot secure some comfort on the statement that in case of doubt, labor legislation should be resolved in favor, under the labor code in favor of labor, under the civil code in favor of the safety and decent living condition of the worker. Because the meaning of the word doubt is very technical. There is a doubt only if the law is subject and susceptible of more than two interpretations, each one is correct. But if you choose to say that there is a doubt simply because it is susceptible to two or more interpretations, you must be sure that each interpretation is correct. And so, how do you apply the rule? If there's a doubt, give it to labor. Why? Because you are liable to collide with the due process clause of the Constitution. How do you resolve it? You resolve it simply by stating that the doubt provision is specific. And insofar as the due process clause is concerned, it is general. And under the rules of statutory interpretation, when there's a conflict between a general statement of the law and a specific provision, the specific shall prevail. So you are able to balance the two rights. In other words, we have accounted for all the provisions of the Constitution. Well, I am just plowing the field all over again, something you have been sitting down for the last 10 days. Labor and the Civil Code. There are several provisions in the Civil Code that have applicability to labor. One, what is the nature of labor management relations? The classic statement of the Civil Code is labor management relations is not merely contractual. They are impressed with the public interest. And because there is an impressed public interest, their relations shall be governed by law. And law means the Civil Code and the Labor Code. And therefore, there is also a standard of behavior. And the standard of behavior says that when the two relate one with the other, they must consider the public interest. And the private interest, neither of them should oppress one another. Now, but there is Article 19 of the Civil Code in the human relations portion. That portion has been used in Book 6 cases. But what about Article 110 of the Labor Code? You will note that Article 110 of the Labor Code speaks of worker preference in case of bankruptcy or liquidation. And the sentence in Article 110 says, any provision of law to the contrary notwithstanding, the claim of the worker will be given preferential rights. However, to bring you back to your classroom, you remember the case of Republic versus Peralta. If you do not remember Republic versus Peralta, you remember at least the DPP cases. And Mr. Justice Feliciano said that the provision of Article 110 cannot be read in isolation of the carefully crafted provisions of the Civil Code on the concurrence and preference of credits. Now, you can be sure that there are two possible subjects in the bar examination where it can be asked. It can be asked in the labor because there is Article 110. It can be asked in civil law because there's the concurrence and preference of credits provisions of the civil code. Second, the civil code contains provisions on work and service, and you will note that those provisions are in addition to what you find in the labor code insofar as the provisions on house helpers. And you will note that under the civil law, under the labor code, house helper has a technical definition. Is any person acting in the service of the employee of an employer who ministers to the comfort of the head of the family and the members thereof, and it includes a family driver. Now, there are provisions of the civil code referring to house helper. And finally, there are the prescriptive provisions of the civil code, most specifically on the law on termination of employment, because the civil code prescription on causes of action with respect to illegal dismissal is not found in the labor code. It is found in the civil code. It's 4 years. What you find in the labor code is prescription of causes of action, criminal in nature, not the civil portion. Then you have international covenants. International covenants means the Universal Declaration of Human Rights, social, political, and the conventions and the recommendations of the International Labor Organization. And you will note that you have the case of the Alliance of School Teachers, which rule that the Philippines accepts international law as part of the law of the land only if the international covenant has been ratified by the Philippine government. In this particular case, equal pay, equal work was ratified by the Philippine government, and therefore the Filipino school teachers would receive the same pay and benefits as the foreign school teachers in the American school. Now, Labor Code of the Philippines. A reading of Article 3 of the Labor Code will tell you that it is applicable to all workers, whether agricultural or non-agricultural. But there were certain cases where the question of the applicability of the labor code was defined. First, private school teachers, as distinguished from public school teachers. Private school teachers are governed by the manual of the Department of Education, Culture and Sports, and the labor code is merely suppletory. And the controversy revolves around the period of probationary employment, because the period of probationary employment under Article 281 cannot exceed 6 months unless a longer period of apprenticeship is agreed upon. But you will note that under the manual of the Department of Education, Culture and Sports, the probationary period is 3 calendar years. Second, you have religious corporations. And in the case of religious corporations, there is a test on the applicability or non-applicability of the labor code. The test is the nature of the controversy. If the nature of the controversy is ecclesiastical in nature, meaning an interpretation of the gospel and the Bible, it is beyond the jurisdiction of the labor arbiter. But if the bone of controversy is secular in nature, namely an interpretation of the provisions of the labor code or related law as it applies to the employment relationship, that is a justiciable issue for the labor arbiter. Government-owned and controlled corporations, it is the law of creation, meaning is the corporation organized under the corporation law, which is the general law of incorporation, then the labor code will apply. But if the corporation is organized under a special charter law, it does not apply. And lastly, you have international agencies. International agencies, by virtue of the document of agreement establishing them in the Philippines, includes what is known as immunity from suits. Because there is an immunity from suits, these institutions are exempt from the jurisdiction of Philippine agencies. The reason behind is it will assure the independence of these agencies in the performance of their function. But all these agencies, the treaties that establish their establishment in the country, should have included a procedure for the settlement of any dispute. If there is an abuse, the remedy of the worker is to ask the Philippine government for a withdrawal of the immunity from suit provision. So you are able to reconcile the applicability clause of the labor code and the special issues, namely government-owned and controlled corporations, private school teachers, international agencies. Now, employer-employee relationship. There is no provision in the labor code. However, you have the latest case is Francisco versus the NLRC. In Francisco versus the NLRC, the court began with the classic statement: there is not only one test to determine employer-employee relationship. We have in the Philippines what is known as the two-tier test. Tier is T-I-E-R-S. The first tier is what you see in the street corner, like the rotary test. It is a four-fold test. It is called the standard test, which is the four-fold test. The test says, 1, selection and engagement of the worker. 2, the payment of wages. Thirdly, the power to discipline. And lastly, the power to control. Both the results and the means. That is what is known as the four-fold standard test. It is the test most often used. But of the four, you have to understand it in the light of judicial doctrine. Judicial doctrine tells it is a two-tier test. We first apply the four-fold test. And then judicial doctrine segregates the last. The last is known as the control test. You control the purpose as well as the means. Means mean how is the work or the service to be performed. The result is the end. How was it done? Was it done in accordance with law? Now, but judicial doctrine now, you can now abbreviate it to just a couple of sentences. First says, of all the four elements or the four factors, control is the most important. It is the determinating factor. Second, but control need not be actually exercised by the employer as long as the reserve rights theory exists. The reserve rights theory means that the employer need not actually control, need not actually supervise, provided the employer has the reserve right to control both the means and the result. But then, you have to be very careful because there is the insular life doctrine. The insular life doctrine says not all forms of control are indicative of employer-employee relationship, because there are certain instances, most especially where the enterprise is imbued with the public interest. And because it is imbued with the public interest, there is a government regulatory mechanism in place. When the employer enforces the government regulatory mechanism, the government says you have to enforce it, and therefore the employer, to some extent, must control the means and the result. But that is not the control mentioned in the standard test. In other words, because of the public nature of the business, imbued with the public interest, and the control mechanism is imposed by law, the employer, in exercising that function, is not going to be an employer. The best example is an insurance agent. So, you have taken care of what is known as the fourfold test. But there is a second test. For those of you who are using an old textbook, that is Sevilla versus the Court of Appeals. The latest case last year is Francisco. It is known as the economics of the relationship test. The economics of the relationship test says, look at the degree of economic dependence of the worker dependent upon the employer. The purpose of the economics of the relationship test is a strict interpretation of the fourfold test may result in an injustice and an inequity to the worker. To remedy that possibility, you have the economics of the relationship test. Focus not on the fourfold test, focus and ask only one question. What is the degree of economic dependence of the worker towards his employer? So you have to look at the nature of the business, the function of the worker, and the control exercised therein. You have therefore taken care of the two. And it's a favorite question of the bar examiner. Independent contractor. You can easily picture the independent contractor and the labor-only contractor if you know the trilateral relationship test. It's a three-level relationship. One, the employer and the independent contractor, or the subcontractor. Second, the employees of the independent contractor and the subcontractor. And finally, the employees of the independent contractor and the subcontractor that are assigned to work with the contract, right? There are three parties. One, the employer and the contractor. The contractor and the workers of the contractor. The workers of the contractor and the employer, the owner of whoever entered into a contract. Clear? But now you must be very careful. How do you relate Article 106 of the Labor Code with Article 109? A reading of Article 106 will tell you that the focus of the law is a guarantee that the worker will be paid in accordance with law. And you are introduced to the concept of indirect employer, direct employer, and when do you convert the indirect employer to a direct employer. So, Article 106 says, in every contract of independent contractor, there must be a provision that the workers will be paid wages, I repeat, wages in accordance with law. And if the contractor or the subcontractor is unable to pay wages in accordance with law, the employer is jointly and severally liable. So a reading of Article 106, your attention is invited right away. 106 is focused only on wages. And second, the failure of the contractor, the subcontractor, to pay wages in accordance with law, what is the legal effect on that failure on the employer? That's why you have the conversion formula. When there is no violation, the direct employer is the employer of the contractor. And the employer that entered into a contract with the independent contractor is merely an indirect employer. But when the direct employer is unable to pay, there's a conversion. The indirect employer now becomes the direct employer, and it is liable jointly and severally for the unpaid wages to the extent of the law. Now, if you compare that with Article 109, you will note that Article 109, the focus is any and all violation of the provisions of the labor code. And you can ask legitimately, if there is a violation of the wage law, there is automatically a violation of the provisions of the labor code. But the intent of the law is to protect that wage at all times. And so it separates. Now, under 109, it is a violation of any provisions of this code, and it is solidary liability, not joint and several liability versus solidary liability. But then you have to connect 106 with 107. 107 says the provisions of Article 106 are applicable in those situations where there is an employer who enters into an independent contractor but is not covered by 106, meaning if I were to build a house, I am not the ordinary employer, but I enter into a contract. The provision of Article 106 automatically will apply to me. In other words, 106 in relation to 107. So, 106, 107, 108 in relation to 109. 109 speaks of bonds, performance bonds. The presence of a performance bond will not relieve the employer of any and all liability. The only benefit of a bond is that the employer can run after the bond in the event that the employer pays the liability. And finally, how do you distinguish an independent contractor from a labor-only contractor? The first is investment in capital or substantial investment in tools, equipment, and machinery. An independent contractor has that investment. A labor-only contractor does not have. Two, the nature of the business. An independent contractor is a separate and distinct business. Labor contractor is not a business. Thirdly, the nature of the work. The workers hired by a labor contractor will perform functions which are usually done by the employer, and therefore, in Philippine law, a labor-only contractor is void. And the net effect of a void relationship is the personality of the labor-only contractor is merged with the personality of the employer, as if the labor-only contractor did not exist. And therefore, the law goes further and holds the employer as the real employer, as if that same employer hired the services of the employees of the labor-only contractor. Now, employee classification. Well, you do not need to bedevil your mind. If you have your labor code, you'll be surprised how simple it is. If you have your labor code, you open it. You open Article 280 of your labor code. Now, just read it quietly, and then you will tell, well, I don't have to bedevil my mind. All I have to do is to master how to apply Article 280. You just read it just for your fun. After all, it's boring doing it by, well, in my case, it's all over. In your case, you're going to go through it. You just read Article 280. Just read it quietly, and you will note that if you are able to do Article 280, you can do it for any article of the labor code. Just read it quickly. So, the key to understanding regular, project, seasonal, and casual is to understand the structure of 280. The first concept of Article 280 tells you any provision of law to the contrary notwithstanding. What is the message being sent? The message being sent is to determine whether an employee is regular, project, seasonal, or casual. It is a legal test. A legal test because the law itself provides for that test. Meaning, it is not the agreement between the parties. It is nothing else other than a legal test. Clear? Secondly, there is a definition and a test of who is a regular employee. A regular employee is any worker who is performing a function usually necessary or desirable in the usual trade or business of the employer. There is then a legal test. The legal test is what is the connection between the employer's business and the workers who work, and the connection is usually necessary or desirable. Now, and here comes the simplest of it all. Except, now take a look at Article 280 and look where the word except is positioned. Where is its position in the law? The position of the word except is immediately after the definition of regular. And who are excepts? 1, project. 2, seasonal. Therefore, and the third, casual. But you will note in the structure of the law, casual is mentioned as the proviso, which means, therefore, a seasonal worker, a casual worker, a project worker may be performing a function usually necessary or desirable in the usual trade or business of the employer, but they are not regular because they fall within the exception. And the theory of the law is there is no continuing need by the business for these workers. But note, while there are exceptions to the rule of regular employment, when you go to the project employee, there is a protective mechanism. The protective mechanism says that when an employee is hired for a project, there is an obligation imposed by law on the employer to inform the worker the name of the project and the duration of the project. A failure to do so is going to be fatal. Then there is the seasonal employee, hired only for a season, even if they are performing a function that is usually necessary or desirable in the usual trade or business of the employer. And you can ask yourself the naughty question, is my bar reviewer a seasonal employee? Well, I cannot answer that question simply because I work elsewhere. But if your reviewer were a part of the UST faculty, I don't know what's the answer. All right. But then you have provided casual employee. And you will now know something odd. If it does not fall in any of the above, by process of elimination, one is a casual employee. So there is no definition except by a process of elimination. But the implementing rules tell you that a seasonal employee is one who's performing a function that is not normally the business of the employer. But note, there is a conversion formula. A casual worker who has worked for a period of 1 year, whether continuous or broken, will now become a regular employee. But as a regular employee, there are two conditions that must be met. One, regular only for the position originally hired. And second, the position still exists. In other words, if one was hired for position A, only for position A would the worker become regular, and only if there is a need for the worker. Now, judicial doctrine tells you regular, performing a function usually necessary or desirable in the usual trade or business of the employer. Judicial doctrine adds one more, viewed as a whole, and you have the entire judicial doctrine in your pocket. See how simple it is. Project, there is the celebrated ALU case which answered the question, should there be a direct relationship between the nature of the business and the project? In other words, what should be the relationship between the project and the regular business of the employer? And note how carefully the judicial doctrine is crafted. First, it says, the ideal situation is there must be a direct relationship between the business of the employer and the project. Second doctrine says, but not all things in life are ideal, and therefore a not ideal situation may occur. no relationship whatsoever, but nevertheless, in both instances, it is valid. But then there is a warning. The first warning tells that while it is true that it is valid, the first warning tells that the two businesses must be kept separate and distinct one from the other. And secondly, it must be implemented in good faith with no attempt to evade any legal liability whatsoever. So, a reading therefore of Article 280 tells you there are two regular employee types. A reading of the whole Article 280 tells you that an employee may be regular, project, seasonal, casual. There is no such thing as a permanent employee because you have Book 6 of the Labor Code, which allows termination for just cause. But secondly, a reading of Article 280 tells you that Article 280 has a built-in definition of regular employee. 1, functions test. 2, the casual after a certain period of time. Thirdly, under Article 281, a worker who is allowed to work beyond the period of probationary employment. And lastly, the learner whose employment is terminated within a 2-month period for no cause of his own, and there is a promise of employment. You have therefore now summed up when is an employee deemed regular, and you have the 4, 280, 281 on probationary, and finally the learner. Now, shall we continue now in the field? All right, recruitment and placement of work. Right now, I have to tell you, there are 2 laws you have to reckon with. 1, recruitment and placement of workers under the Labor Code. And recruitment and placement of workers under the Migrant Workers Law, Republic Act 8042. Where is the dividing line between the two? The dividing line between the two is under the Labor Code prior to Republic Act 8042. Recruitment and placement of workers was defined as employment locally or abroad. That was the state of the law prior to Republic Act 8042. But you will note historically that Republic Act 8042 is the product of the Flor Contemplacion case. In fact, it was a movie, the Flor Contemplacion story. God bless her soul. She was the lady who was hung in Singapore. The knee-jerk reaction of the Philippine government was to pass the Migrant Workers Law. And the Migrant Workers Law defined who is a migrant worker. And the definition of a migrant worker under the Migrant Workers Law is one who will work in a country where the worker is not a citizen or a permanent resident thereof. What is the effect of that definition? The effect of that definition is to repeal the abroad portion of the Labor Code. And now the law divides. If the worker will work in the Philippines, it's the Labor Code. If the worker will work abroad, it is the Migrant Workers Law, simply because there is a definition of a migrant workers right now. But where is the heart of the law? You cannot solve any problem on illegal recruitment unless you know by heart Article 13B of the Labor Code, which is a definition of the term recruitment and placement of workers, and Article 34 of the Labor Code, which is an enumeration of the prohibited practices acts, and Article 38, which is illegal recruitment, and the definition of license and authority under Article 13 of the Labor Code. And secondly, you have to memorize Section 6 of the Migrant Workers Law. Now, excuse me, you have the two laws. So the first discipline of the mind is this: where are they similar? Where are they not similar? That's the focus. 13B, which is a definition of recruitment and placement of workers, is exactly the definition in Section 6 of the Migrant Workers Law, because the Migrant Workers Law copied verbatim the same, exactly the same. License is exactly the same in the Migrant Workers Law. Authority is exactly the same in the Migrant Workers Law. But Article 34, which is the prohibited acts or prohibited practices, was copied verbatim by Section 6 of the Migrant Workers Law. But the Migrant Workers Law added two more acts, meaning two more acts were added by the Migrant Workers Law compared with that of the Labor Code. Article 38 of the Labor Code, which is illegal recruitment, is exactly the same as. Now, where is the difference? A violation of illegal recruitment under the Labor Code says that the agency must have no license or authority, and number two, has committed an act defined as recruitment and placement of workers under Article 13B or the prohibited acts under Article 34. And the violation becomes economic sabotage if it's committed as a syndicate, three or more, confederating and conspiring against the worker, or it is considered large scale, three or more workers are involved. Now, where is the discipline now? The discipline is this: if if the agency violates Article 13B under the Labor Code, there is a requirement that there is no license on the part of the violator. That's exactly the same in the Migrant Workers Law. No difference whatsoever. Where is the difference? The difference is Article 34. In Article 34, the agency here has no license or authority, and he violates Article 34. But in the case of the Migrant Workers Law, the difference is now clear. If the violator has a license or no license is totally irrelevant. In other words, a violator of Section 6 can commit an act of illegal recruitment, A, if the act is 13B, That means no license, no authority. But if it is Article 34, whether he or she has a license is totally irrelevant, is immaterial. That's precisely the floor contemplation of this story. Now, the next discipline of your mind. Article 34 can be violated by the holder of a license or authority, because Article 34 is specific. The holder of a license or authority can violate Article 34, but he may not commit an illegal recruitment, because the law now says that if you violated independently Article 34 and you have a license, the act committed is a violation of the law and the penalty is less compared to that of illegal recruitment. Is it clear? It's a question of just putting the two side by side. Clear? And finally, Section 10 of the Migrant Workers Law has been declared unconstitutional. And that is with respect to violation of the contract, meaning pre-termination. The provision of the law has been declared unconstitutional, and therefore the provision of the Labor Code would apply if the contract is pre-terminated. The liability of the employer is to the extent in full of the unexpired portion of the contract. Well, those are the important provisions of the Labor Code. The rest are easy reading, except Book 6, which happens to be the law on termination of employment. And it happens to be my area. Now, I'll discuss it in full tomorrow, but there is a simple guide for you to follow. A reading of Articles 278 until Article 287, which is the law of termination of employment. What is the line? 278 lays down the fundamental principle. The law is applicable regardless of the nature or purpose of the enterprise. Whether the enterprise is organized for profit or not, the law on termination of employment will apply. And there is a line, Article 2, Book 6, 282, 283, 284 are known as the just causes for termination of employment. Article 287 is retirement, employment termination, right? Your second guide is one size fits all. A reading of Article 282, just causes for termination of employment. Article 283, other causes. Article 284, disease. You read it within the context of Article 13, Section 3 of the Constitution, otherwise known as the security or tenure guarantee. All cases involving Article 282, 283, and 284 must be read in the light of the security of tenure guarantee. Second, there are substantive and procedural due process requirements, which tells you that the first question you should ask whenever the case involves termination of employment is, has the cause of action prescribed? If it has not prescribed, is there compliance with substantive due process? Is there compliance with procedural due process? And as you read it, You focus on your good friend, a Gabon versus the NLRC. There is no more mercury drug rule. Clear. Your third guide is, you read Article 282 very carefully. And you will notice that you can easily be misled because you are reading selectively. That is something you should not do. Because there is a qualifying phrase for every act. It is not misconduct, it is serious misconduct. It is not disobedience, but willful disobedience. It is not negligence, but it is gross and habitual. Commission of a crime against whom? And finally, the word analogous. So if you read Article 282, you focus on three things. What is the qualifying phrase? What is the connective? And finally, what are the requirements for it? Because for each ground mentioned in Article 282, there are certain requirements. And Article 282 must be read in the light of Article 277B of the Labor Code. Article 283 refers to other causes, but you will note that there are business-related causes. But the procedural due process requirement of Article 283 is built in Article 283, and therefore Article 277 will not apply because the procedural due process requirements under Article 283 are built in. Notice requirements. But if you read Article 283, you also have to read Article 277 of the Labor Code because there is a procedural requirement that the notice in writing must be given not only to the worker but to the Secretary of Labor and Employment. And the Secretary of Labor and Employment has the authority under the Labor Code to stop termination of employment if it is en masse and will lead to a serious labor dispute. And finally, you have Article 284, which is disease. 282, 283, 284 answers what is substantive due process. Substantive due process is cause. The second question you ask is there compliance with procedural due process? And procedural due process is 282 and 277B. And therefore, you answer the first question. Is there compliance with substantive due process? Is there compliance with procedural due process? And what are the remedies and the sanctions? And you have Article 279, which talks of the twin remedies. And finally, you have to read Article 223 because if there is an order of reinstatement, it is automatic reinstatement and the provision is found in some other provision other than Book 6 of the Labor Code. And lastly, you have to go through other causes very, very carefully. And as you read Article 287, you must make a distinction between the worker who works in the extractive industries, meaning underground, and the workers who work above the ground, on the ground, because their law of retirement age is different. And number two, read the formula for computing. Clear? Now, for Book 5 of the Labor Code, it will be a lot easier for you. If you read as your base Article 13, Section 3 of the Constitution, which is policy declaration. You read Article 211 of the Labor Code, which is a policy statement, and you read Article 211, big A, small a, immediately in relation to Article 211, big B, because big B is related to Article big A, small a, and big B provides for the exceptions. And lastly, we must be able to read very carefully the definition of terms in Article 212 of the Labor Code, just to illustrate what is meant. If you open Article 211 of your Labor Code, you will know. You open it. Now, Article 211, big A says, it is the policy of the state. But you will look at the bottom, there is paragraph big B. It consists of two parts, big A, big B. Big A has a small a, small b, small c, small d. But big B stands alone, right? But there is a connection between big B and big A, small a. Where is the connection? It's not like the bread connection you see on the mall. Big A says it is the policy of the state. A, to promote and emphasize the primacy of collective bargaining, negotiation, arbitration, and conciliation as modes of dispute settlement. Say, primacy, it is to promote and emphasize, promote, emphasize primacy. That violates the rules of grammar. If it's primary, it must be important, right? If you emphasize, you underline. Anyway, that's which brings me to the point. If you are expecting that the questions in the bar examination will be the King's English, I can assure you, you will be disappointed. And every time you read a bar examiner writing an article, the reason they do not pass my examination is because they do not know how to read and write English. You can write a letter to the examiner. Mr. Examiner, stand in front of the mirror, point your finger, that finger is pointing at me, but look behind, 4 of the fingers are pointing at you. It may be the cause for the examination's question not being understood. And I can assure you, some of them do not understand the question themselves. I'm not saying, I'm only stating a fact. Anyway, where is the connection? Promote and emphasize. Now you jump to big B. Big B tells you, in order to promote the democratic way, no court or agency of the Philippines shall have the authority to promulgate wages, hours of work, and other terms and conditions of employment. What does it mean? It is repeating what is said in A in a different sentence. But banana is banana, no matter what the color of the skin is, right? But then it says, except as otherwise provided for in this code. So if you look at the structure, big B reiterates what is in big B, big A, small a, but it provides for the exception, which now tells you that the labor code takes care of two situations, the ideal and the not ideal, meaning when the public interest is involved, the law now changes as to what will be the method of dispute settlement. It is the exception you have to look for, Liam. And you will note that the entire Article 211 after Article 213 is nothing but an implementation of what you find in Article 211. Now, if you look at Article 211, you look also at Article 275, which means tripartism as a mode of policy. And then you have Article 254 on the limited use of the labor injunction. You have a complete picture of labor relations policy. And the second key to understanding the Labor Code Book 5 is to read Article 212. Article 212 is definition of terms. But if you read Article 212 very carefully, you will note that there are 5 terms where the word includes is used. The rest says means. So, you read it and you will notice 4 or 5 uses the word includes. An employer shall include any person acting in the interest of an employer. An employee is any person. Now you have to be very careful. Any person in the employ of an employer or is the victim of a current labor dispute and has not obtained a substantially equivalent and regular employment. Means includes. When you see the word include, the meaning is that the definition is not complete. It's not complete, and therefore it accommodates the ordinary dictionary definition. But when the law uses the word means, the definition is complete. The intention of the law is that there are certain terms in order to achieve the objective of the law that should not have a complete definition. And lastly, your guide is it a substantive provision of the law? Or is it procedural? Or is it both substantive and procedural? If you are able to do so, and I am sure you can, because you have survived law school and you have graduated from a good law school, then you should not fear the bar examination. It's just one of the rituals in life. If it is any consolation to you, there is a school of thought which believes that there should be no bar examination. The question is, they were only exempting one school, which is not fair, right? But if you are going to be consulted, just remember your code of professional responsibility. The legal profession is neither a trade nor a business, but it is a profession, right? And therefore, in the language of Cardoso, it is a noble profession, an exacting profession, which requires that you must burn the midnight oil. But there is a sociological definition of the term profession, and that is your consolation. A profession sociologically is defined as one that requires systematic formal study in a university. And secondly, the profession is legitimized by a government examination. Popularly, romantically, whatever you want to call it, it's called the bar examination. And it includes a ritual. The ritual is, I must sit down for 5 months, attend a bar review. Whether the bar review will help you or not, only you and your conscience can answer. Whether your bar reviewer can help you or not, that leaves to the same. All right, that being so, do you have any questions? So, the If you have any questions, ask them now.